Hi, this is Dave Henning with Freshstart TV, and my guest today is Travis Krepelka with Hoover Krepelka Law Firm in San Jose, California. And Travis is an expert in family law. Welcome, Travis. Good to have you here.
Thank you so much, Dave.
So I'm going to just read this little thing real quick here that I actually found on your website because it can set the stage for what we're going to talk about. Our attorneys and entire staff share a common vision. We care about people. For that reason, our lawyers work as a team to create meaningful strategies to solve complex family law problems. Travis Krepelka is both recognized as a certified family law specialist by the State Bar of California Board of Legal Specialization, an honor bestowed to approximately 10% of family law attorneys. So congratulations for that.
Thank you.
And so, obviously, you are dealing with one of the most complex legal issues out there, and that is family issues, family divorce, child custody, things like that. So I suppose one of the first questions that people might ask is, well, sounds pretty expensive. How much does a divorce cost?
That's a great question, and one that a lot of lawyers, I think if you went around looking for a divorce lawyer, a lot won't answer. I'm going to answer that question here for you, and I like to answer it for my clients. And obviously, like with a lot of legal questions, there is a certain amount of it depends to the answer. But what I can say is I've handled enough cases. I've probably handled at least 1,000, if not more, divorces at this point over 15 years. And I can definitely say, in my experience, what the bell curve looks like in terms of the time it takes and the cost of a divorce. And so I will say, and hey, let's get the sticker shock out of the way. You know, it is a lawsuit. Litigation is expensive. Lawyers can be expensive. That's why people don't like us. But your average divorce, it will probably take about 18 months from start to finish.
Wow.
It will probably cost about 40 grand. That's sort of your tip of the bell curve. That captures maybe 2/3 of people, I would say.
Mm-hmm.
Expand the bell curve out and you want to be more certain that you'll fall within a range, I would say anything from 12 months, from 1 year to about 2.5 years, 25 to 75 grand. If you come in less than a year, less than 20 grand, you've done really, really well. You should pat yourself on the back. If you are nearing year 3 or you're nearing 100 grand, everybody's to blame. You, the client, are to blame. I'm to blame. The other side is to blame. The other lawyer is to blame. We all need to take a look in the mirror and figure out what has gone wrong here. So, that's the curve of it there. 30, 40 grand for your average divorce.
So what I hear you saying is part of it is contingent upon, am I hearing this correctly, that how quickly that one of the spouses or both spouses basically take action? Is that right?
For sure. And there's a lot of reasons why things can be more or less expensive. Going to court, litigating is what is the most expensive aspect of a case. 90 to 95% of our cases do settle. We try to stay out of court. But divorce is interesting because it's a lawsuit. You have a plaintiff, you have a defendant, called petitioner and respondent in a divorce. But there's a summons, there's a case number. It says right on it, you're being sued. And yet these are people who had this relationship that lasted however many years. There's a lot of complex emotions, and invariably, one of the factors that we have to work through, that one of those people is going to be further along in their emotional grappling with where they're at in the end of the relationship. One person is invariably readier for this to be over because they've been thinking it's over, or they've made the decision, and the other person has to catch up. And so a lot of the delay in a divorce is the fact that people, one for sure, and oftentimes both, are not just, for understandable reasons, not emotionally ready to take a step back and just be calm and reasonable and compromise.
Yeah, exactly. So, and there's so many complexities, as you said. For example, they may already be separated. They may still be together. They may have dogs and cats. Who knows? Right. Everything that's included in the assets. It's a very complex issue. But some of these testimonials that I've read about you are outstanding, quite frankly, that you're able to give people in the midst of a tragic emotional situation a sense of peace of mind.
Well, yeah, and I appreciate anybody who's written testimonials that are out there somewhere that you're able to read. All I can do, I feel like, is communicate. at the end of the day. I listen a lot to clients that come over. Maybe they've had a different lawyer and they're switching over to our firm, or I just generally get a sense of the complaints people have about lawyers. And what I find is it boils down to a lack of communication. People can handle a bad result. They can handle a negative experience if they were prepped that was likely to happen, or was at least on the range of options of what could happen. And people can handle bad news from their lawyer or rough times that have to be confronted if they at least have this expert that they can quickly get a hold of. So from my standpoint, honestly, and I think that's probably what some of the people who might say some nice things have experienced, I can't fix a really awful situation, but I can usher someone through it with expertise, and more importantly than expertise, with responsiveness and to educate them.
Sure. So
on a lot of levels, it's like going through, it's like working with doctors, whether you're going through a cancer treatment that you're going to get through, but it's going to be really hard, or any other, pick your analogy within the world of medicine, but it's very, very similar, where you can go through all of that nastiness if you just know that your professional that you've entrusted is there for you, is going to pick up the phone when you call, going to answer your email when you send it.
And I think you hit on a key point, is that people are fearful initially, a lot of fear involved of, well, what's involved, how long is it going to take, how much is it going to cost, just the unknowns that you have a skill, as you said, as communicating. So what's perhaps the biggest advantage of hiring a qualified attorney?
Ultimately, it's going to save you money in most situations. And let me explain that. I'm sure there are people out there that go through a divorce process smoothly and amicably, and they figure out how to fill out the forms, and they spend next to nothing, and God bless them. Good for them. Absolutely good for them. But usually what you accomplish when you choose to, I think, do anything without a lawyer, again, to stick with the medical analogy, you're not going to perform your own surgery on yourself. You're not going to take out your own appendix,
No.
So, and any world where there is a niche of expertise, what usually happens almost all the time when you try to go it alone is you make a bigger mess of it than it was in the first place. And so you end up spending more money than you needed to spend because you now have cleanup that didn't need to happen or could have been avoided.
Exactly. That's like me still trying to fix my car.
Right.
Kind of breaking something.
Exactly.
Oh, well, so some spouses might want to know right away, hey, who gets to keep the house?
Sure. Houses are, especially here where we live in this, I think we're living in here in the South Bay and just in California generally, and certainly the Bay Area as a whole, it's got to be one of the most insane times to live in terms of a housing market. And so people, especially if they've owned their home for any length of time, find themselves with a tremendous asset on their hands. I mean, I think in an average life, a person's home has always kind of been their big asset. You take your kind of average family, but now more than ever, right? Now more than ever, we have these homes that are, 1.5 to 3 million that used to be nothing like that. So now you've got this big asset, biggest asset of the case. Okay. Now you've got the kids growing up there, and you've got emotions that are connected. People, myself included, I love my home, right? I mean, I totally love my home, and it's devastating to think of what would happen if I lost it, whether into a divorce or, God forbid, a fire or anything. We get very emotionally attached to our homes for a variety of reasons. And now here you are in a divorce, and I can tell my clients, and this is part of the education, it's super simple under the law. The law lets only 3 things happen. One spouse buys the other out. The other spouse buys the other. You see what I mean? Like he can buy it, she can buy it, or some third party can buy it. When it gets sold. That's it if you go to court and want to argue about it. Now, there's a whole range of options if people can settle. People can come up with a lot of creative things. You can come up with a deferred sale where maybe one party keeps it for 3 years, 5 years, maybe until the kids get out of high school, something like that. One party continues to live there. Then you sell it down the road. That's an option. You can engage in kind of a bidding war, where you each go out and get appraisers, and you kind of, each side is, hey, I'm willing to pay this for it, I'm willing to pay that for it. You can negotiate and offset. Let's say the person who wants to keep the house is also the one that's owed spousal support. You could start to tally those things against each other, and you could, a person who can't otherwise afford to buy their spouse out of the home might be able to keep it if it was a good idea, by offsetting against support or any other claims that are owed. So there's a whole spectrum of things we can do in the settlement room. But if you take the issue to court and fight about who gets the house, it's him, her, or him, or her, or some third party.
Wow. So, boy, that really clarifies a lot. It answers a lot of questions that people might have immediately. Where am I going to live? So, and then do clients typically have to go to court if you're going to court on their behalf? They go with you. Is that how that works?
If we're dealing with substance, there are proceedings that are purely procedural in nature. Has this been done? Has that been done? Where are we in the process? Where it's just the attorneys there telling the judge what's going on procedurally. But otherwise, yes. If we're dealing with anything of substance, my client will be there with me in court. Back to my bell curve of about 18 months, about 40 grand. That case is going to go to court twice on smaller issues, not insignificant issues. When I say smaller, I mean not that time consuming. That's my definition of smaller here. The issue could be millions of dollars, but can we handle it in 30 minutes or 45 minutes as opposed to 3 or 4 days? So yeah, your average case will see the inside of the courtroom a couple of times. Maybe it's to establish an initial child support number or an initial parenting time arrangement with kids. And a lot of the times it's out of the gates where emotions are the hottest, and some of the stuff that has to be figured out so that people can live their lives, they're just not in a position in those first 3 months to do so unemotionally. And so you end up in court early, and then cooler heads prevail. People start to see how expensive it is to go to court. And like I said, 90+% of cases settle on the whole.
Sure, and those emotions might last for years and years, for that matter, especially if there's kids involved and mitigating circumstances, things like that. So, well, let me ask you this. This might be an off-the-wall question, but maybe not. So have you run across the clients or who they're going to court with? Is there a certain level of lying going on? I don't know how else to say that.
There is, and it's sad. And I've grown very cynical. And so I'll tell you an anecdote if I can, because this is something that I have to speak with my clients a lot about. And I try to explain how it's going to feel, how we need to pick our battles. But let me share my anecdote. So when I was a younger lawyer, so we're talking a dozen to 15 years ago, I was very bent out of shape about perjury and the lies that get told in court. And I was really insisting. I had one easily proven. I had, the document, the paper that disproved the statement. And I was there and I had shown the court, and the court didn't seem to care. And I was getting more and more agitated. Why is this judge not upset with this person who's standing in here lying? And I've just proved it. And I was getting a little bit heated. And the court finally said, it was like, time out, Krepelka. Let me tell you something. The judge says to me, I've got back in my chambers a form I can fill out where I can refer people who lie in my courtroom. I can refer them over to the district attorney for prosecution for perjury. And in family court, if I did that, every time somebody came in here and lied to me about one thing or another, I wouldn't have time to do what I'm doing right now to judge a case. I would literally be able to do nothing but fill out those forms all day long. Now, that's a deeply cynical view. But there's a lot of truth in that. And if I can take another couple minutes on this point, because I do think it's important, and it's something a lot of people, good-hearted people, don't expect. So there's that old adage that there's, 3 sides to every story. There's my side, your side, and the truth.
Yeah, you're right.
There is something to that. So a lot of the time where I have a client who's upset that the other side is lying, I can see that I don't know exactly where the truth lies in the middle of what they're saying, and it very well may be that each of them believes what they're saying to be true. That's a lot of the lying that happens. But there certainly is plenty of lying in family court that someone they know they're lying. It's not a matter of perception. And with that, I try to get my clients to understand we have to pick our battles. You're never going to carry the day on a he said, she said. You can say the other person is lying, but unless I like documents. If I'm going to prove someone's lying, I better have an email, a text, a bank statement, whatever it might be that I can put under their nose. That has a certain amount of dramatic heft in the courtroom. If I can cross-examine someone who has just lied and show a document that the judge can be looking at, having just heard the testimony a minute or two before. But even then, if that lie does not materially pertain to the issues that were there for it, it has no place. And I'm going to be the one who upsets the judge if I try to waste court time on a lie that was provably a lie, but immaterial to the issues. So, I hate to put the little, I guess, insider peek is what this my last minutes is, but call me a cynic. And I'm certainly not, I guess it's important that I say this, having said all of that. My clients better not lie. I have certainly fired clients for lying and will fire them again for lying. I'm not going to lie for anybody. I've been asked to and never would. To me, that's more and more important in a world where there are a lot of lies told, is you have to be able to go home and sleep at night that you at least did things the right way.
Well, as I said at the beginning of this interview, you're in one of the most complex areas of law, and I'm sure there's lots of areas of law that are complex as well. But
sure, Dave, can I throw in one more sentence in answer to that? Because I want to offer a little bit of comfort to go with the cynicism.
Absolutely.
I only have one case in mind, one incident in mind, where the lying demonstrably won the day for the liar. In other words, that judge who told me it happens all the time, the judges also see through it. That's where I want to put people at some ease. I only have, out of hundreds upon hundreds of court appearances and issues, thousands of issues, I can only remember one time where a liar won by virtue of the lie. Usually the judges just kind of assume you're lying. I don't care I'm just going to go to, what does the bank statement tell me? What does the formula show me? Can I hear from the teacher how the child is doing? So the judges, they see through it.
That's great. That's great to know. Sure. And I kind of expect that. And of course, I confess, I like Perry Mason and some of these shows where they can resolve something in 30 minutes.
Yeah.
Not going to happen.
Nope. So the Perry Mason moments are few and far between in the real courts of law.
Exactly. As are most TV shows, quite frankly.
Yeah.
So what's the most important rights one should seek to protect prior to proceeding with the divorce?
That's a great question. There are, I probably have a couple tips. I'm reacting to this right now that I would give people. I will also say that people definitely can overthink their divorce preparation, right? I mean, I welcome people to come in for a free consult, even when they're just thinking divorce is a possibility, but we're not plotting. And attorneys out there are not plotting and helping people plot their divorces. So really what's important is to make sure you have protected things that might be difficult to obtain or to restore after you separate and the emotions are hot and you're no longer living under the same roof. For example, documents, right? Passports, birth certificates, childhood photos and things that are of personal importance to people that are invaluable in both definitions of the word. They have value beyond comment and they also have no monetary value. Things of that nature. Let's say you're the person who thinks you're going to move out. Take the time to take with you the things that are precious to you. I hate to say it. I mean, if something was to go lost or go destroyed out of spite and nastiness from the other side, it's going to be those things that are most precious to you. So secure those. Things like, bank statements, credit card statements, tax returns, title documents for homes. We can get those from the relevant banks and county records and stuff. That stuff is not as important if they are U.S.-based financial institutions. If someone has overseas banks, the proverbial Swiss bank account, get copies of those, get JPEG phone photos of those before you're out of the house. And then in the world of time with the kids, I will tell you, setting up a status quo is important. One thing I see, and I see it from dads and moms alike, is for a marriage to have ended and people to have separated, it's going to have been bad for a while. weeks or months at least, often years. And a lot of time, by the time it gets that bad, there's a tremendous relief of living separate and just not having that nightly argument or tension. And so what I will see is somebody will move out and they'll suddenly, look up and realize it's been 3 months and they've kind of barely seen their kids, but a couple times on a Saturday, even though they were very involved while living under the same roof, just because it was just a weight off their shoulders to not be fighting and to be out of the home. And then they finally, it's so easy for 6, 8, 10 weeks to go by. And then they come get a lawyer and they come hire me and we try to set up an initial, time sharing arrangement with the kids. And the other side says, hey, status quo is, post separation is you don't really see the kids. Mm-hmm. So that's a huge tip I have for people is when you're going to move out, which is going to be important to do and needs to happen. We need to alleviate those interpersonal tensions. Make sure you do it with a plan that keeps your kids in mind, because they're not divorcing their parents and they're entitled to continue to see both of their parents as much as they can. So those are kind of my two. On the financial side, I guess 3 things, right? Stuff that's important, souvenirs, childhood memorabilia, stuff that has no monetary value, secure that for yourself. Financial records, secure for yourself things that might be difficult to obtain, knowing that US-based stuff is easy to obtain, less to worry about. And then on the custody side, make sure you're involved with your kids and you can't even take a day off when it comes to kids, as people who have kids know.
That's excellent advice on so many counts, as you said, to lay that out clearly and plainly. Thank you very much. And as you well know, kids take it personally. They blame themselves sometimes, which is sad.
Yep.
But what is the date of legal separation, and what's that all about? Why is that important?
Super important and super misunderstood. There are people will come in and say we're separated, and they're not. People have a total misunderstanding. People have a total misunderstanding about separation, legal separation, date of separation, trial separation. So let me quickly explain all of those things. Legal separation is an alternate checkbox on a petition. You can petition for divorce, most people do, or you can petition for legal separation. And then you can go through the exact same process, do all of the same stuff we've kind of been talking about, going to court or not, settling the case. I wouldn't change anything I've said, whether you're pursuing a legal separation versus a divorce. I won't waste the time right now explaining why someone might elect for legal separation. There are very few times where it would make sense to do legal separation these days as opposed to divorce, because it's a same legal process that ends with a judgment, and it ends with a judgment that you're legally separated, which means technically you're still married. That's legal separation. That's like the end of the line. You have this judgment, very, very rarely used, and for good reason, kind of an antiquated approach to ending a relationship. A trial separation is something my clients talk to me about, and they'll say, we're separated, we have a trial separation. That has no legal meaning whatsoever. That's what people do where they try something out. We need some space. Somebody moves out for a while. They say to each other, we're going to go to counseling. We're going to see if we can work on the marriage, but let's live apart for a bit. That has no legal meaning. There's no such legal thing as a trial separation. Now I dismiss those two separation notions that I hear people talk about to hone in on the one that's super important, which is the date of separation. So from the date that people marry until the date of separation, the law presumes that everything that happened is community. The law presumes that all assets acquired are community, and that all debts or obligations that are owed are community. And there are various ways to disprove that, and various times that things are in fact someone's separate property, whether asset or debt. But from the date of separation onward, which can be well before people actually file for divorce or hire lawyers, let alone go in front of a judge if they need to, there's this window from date of separation onward where the law now presumes that everything that happens is the separate property of the person who is acquiring this asset or incurring this debt. So as you can well imagine, this is critically important. And it often creates a mess during that window between date of separation and the involvement of the legal professionals, because you have people who now have their separate property income because they go to work and that's now their separate property. They're using that to pay a whole bunch of community debts that are ongoing, the mortgage, the rent, credit cards, kids' school tuition, all of the above. You're racking up reimbursement claims, cross reimbursement claims, complex kind of transactional analyses of community and separate property, and you're making a mess, as we talked about, having not hired a lawyer in the first place. You've now made a mess for your lawyers and for the court and made it more expensive. The data of separation, what constitutes the data separation in a nutshell, and it can be the subject of argument and sometimes is because of how important it is, because it cuts off that community presumption, is when it's kind of a two-part legal test. The first part subjective, did either party feel in their mind, in their heart, that the marriage was forever over? That's easily satisfied in court. Somebody takes the oath and says, I felt that way. That's the easy part. Part two of the test is objectively, did they do something to communicate that intention that the marriage was forever over? Did they do something that communicated that to the other side where any reasonable person objectively would understand, I get it. I get what you're telling me. This is over. So in my opinion, the only sure way to set a date of separation, frankly, is to serve someone with divorce papers. That's about the only really guaranteed way to unequivocally communicate that this is over. But there are lots of other ways. And I would say 90% of the time people agree on the date of separation. There was some discussion that happened or something where they can point to a date and they agree. Another 90+% of people, even when they disagree, it doesn't matter. As we start to look at it, we'll learn that there's no monetary difference between the two dates that they say, so we don't have to actually fight about it. And then in a very, very rare amount of cases, maybe 1 in 500 cases, there is a significant enough dispute that has a significant enough monetary value that people might have to actually think about going to court over it.
This has been an excellent discussion and very enlightening for those that kind of want to get a feel for what is this all about, what's it include. Thank you so much, Travis. And before we wrap things up, I did want to ask you what's the best way to contact you. I do know that you have a complimentary consultation. Tell us a little bit about that.
Sure. We do give free consults. Our firm, our founding partner, Bob Hoover, who started practicing family law in 1960, has never, and that's the founder of our firm, and that's the firm that continues now as Hoover Krepelka, has never charged for a consultation in, nearly 60 years now, and we never will. To us, that's super important. I use the example of going through a really intense, difficult, trying medical procedure or process over a year or so. It's very similar to us. You have the right as a client to see if there is rapport with the attorney, see if you like the attorney, see if there's some trust, see if you think I know what I'm talking about, right, before you put down any of your hard-earned good money. So those consults, we provide up to an hour. We set them for an hour. Sometimes I don't need a full hour, but people are certainly entitled to it. And the best way to contact is just to, get on the website, call the phone number that's on there. Once someone is a client, then we're very email based, but the best way for someone who's interested is to just call the number on the website. As
you said, it's important that you on both sides have a good fit and it makes sense. And so that free consultation is very valuable, priceless, as we'd say on the credit card commercial, right?
Yeah.
So, and your website is?
HooverKrepelka.com.
Okay.
I'm the one with the last name that's, tough to spell, but people can find us.
Just Google it. Google knows everything, right?
Exactly.
Travis, thank you so much for your time today. We appreciate it. And we will be sharing this with our Fresh Start TV community as well. So
sounds great, Dave. Thank you.
Thanks.
All right.